Hi friends, in this video we are going to deal with the case summary of the latest Supreme Court judgment pronounced now in the area of criminal law, especially matters involving positive action proximate to the time of suicide on the part of the accused which led or compelled the deceased to commit suicide should be established for conviction under section 306 of the IPC. Please watch this video fully to know more about the suicide abatement case. If it is helpful to you, please like, share and comment, and never forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled Mariano Anto Bruno and Another versus the Inspector of Police, pronounced on 12th October 2022, the Supreme Court has held that positive action proximate to the time of suicide on the part of the accused which led or compelled the deceased to commit suicide should be established for conviction under section 306 of the IPC. The facts of the case would be that the deceased mother lodged a complaint against appellant number 1, appellant number 2, the mother-in-law and the father-in-law of the deceased for the offences punishable under sections 498A and 306 of IPC. After that, the FIR was converted from section 174 of CRPC to section 498A and 306 of IPC. After the trial court convicted the husband and the mother-in-law under section 498A and 306 of the IPC. However, it acquitted the father-in-law of the deceased of all the charges. The High Court upheld the appellant's conviction for the offence under section 498A and 306 of IPC on appeal. Being aggrieved, the appellants preferred the present appeal. The Supreme Court has held that to convict an accused under section 306 of IPC, the state of mind to commit a particular crime must be visible regarding determining the culpability. Also, each suicide is a personal tragedy that prematurely takes an individual's life and has a continuing ripple effect, dramatically affecting the lives of the families, friends, and communities. However, the court of law should not be guided by emotions or sentiments while adjudicating. However, the dictum is required to be based on the analysis of facts and evidence on record. A bare perusal of the impugned judgment indicates that the High Court erred in recording the finding that there is sufficient evidence for convicting the appellants under section 306 of IPC, losing sight of the fact that there exists no evidence on record indicating that the deceased was meted out with harassment by the appellants just before her death. It is well settled that not only there has to be evidence of continuous harassment, but there should be cogent evidence to establish a positive action by the accused which should more or less be proximate to the time of occurrence, which action can be said to have led or compelled the person to commit suicide. In the present case, the complaint against the appellants was filed 3 weeks after the deceased's death. There is no evidence concerning the offence alleged under section 498A of the IPC meted out to the deceased by the appellants. There was no marital discord between appellant number 1 and the deceased during their 9 years of married life. Several emails were exchanged between appellant number 1 and deceased sisters, whereby appellant number 1 was showered with praises for taking care of the deceased in the best possible manner, and credit was also given to his parents for supporting the deceased in her career. Further, it was sister of the deceased who herself sent a mail to the appellant number 1 saying Emily is fighting a disorder. Thus, the deceased was suffering by bipolar disorder and had suicidal ideas from a few days before suicide. Further, the deceased was also undergoing treatment for depression as she was showing significant symptoms of depression like tiredness, poor sleep patterns, and demoralized feelings, to name a few. The fact that the deceased suffered from bipolar disorder was concealed from the appellant family during their marriage. The trial court and the High Court did not consider the evidence of PW9, the psychiatrist, while convicting the appellants under section 306 and 498A of IPC. The appellant's conviction is solely based on the oral evidence of the mother and sister of the deceased, who are interested witnesses. Post-mortem report does not give the cause of the death, but on 15 December 2014, the cause of the death is shown as asphyxia due to external compression. Having considered the facts of the present case in juxtaposition with the judgments referred, and upon the appreciation of evidence of the eyewitnesses and other material adduced by the prosecution, this court is of the view that trial court wrongly convicted the appellants, and the High Court also not justified in upholding the conviction of the appellants under section 306 and 498A of the IPC. Thus, the impugned judgment passed by the High Court and the judgment and order of the trial court are unsustainable and deserve to be set aside and are hereby set aside. The appellants are acquitted of the charges levelled against them.